The Home Office is fighting a losing battle to deport migrants convicted of very serious offences who they describe as a danger to the community because the laws allow those convicted of these offences to rely on reasons that say they would be at risk if they are returned to their home country, and thus tribunals ultimately ruled that they can stay here. So this is one such story. It's from the Daily Mail, and I'll explain from the Tribunal a little bit more about this decision. So first of all, if you are new to me, I'm Daniel Shansmith, the Barrister of England and Wales. I enjoy helping you to understand law and how it applies to current events, so I'd really appreciate it if you subscribe to my channel. I am independent. I am not part of the big media out there. So let's take a look at this. So some people criticise the Daily Mail, but actually it's got this story reasonably spot on. And I'll show you the tribunal decision that backs that up. So this headline, I will try to mitigate some of the words because YouTube doesn't like smallish channels like me compared to some of the news channels reading these words out. So I will use alternatives. So it says, migrant who R-worded sleeping woman avoids deportation after claiming he's bisexual and his life would be in danger if sent back to Jamaica. Now, let's look at this twofold. There are two ways of looking at this. I like to give you a balanced view here. On the one hand, if he is in serious risk, if he returns back to Jamaica, then on a human rights level, we wouldn't want another human to be punished in that way. But on the other hand, if he's here and he was here illegally, because as it turns out, the Home Office made an order to deport him, so he would have been deported, and he's convicted of a very serious offence, then many people may feel that they don't want him in our society. So there are obviously two sides to this coin. This video is not intended in any way to stir up any kind of hatred or hostility between the two points of view, but they are two very distinct points of view that you are entitled to have and to express within reason. So back to the story. The Daily Mail headline encapsulates that reasonably well. It says that he R-worded a sleeping woman and won a bid to stay in the UK after arguing that his life would be in danger if he returned to Jamaica because he's bisexual. He was 41 years old and claimed that he didn't know that having sex with a woman who was sleeping was wrong. He was granted anonymity for his own protection, so that he obviously wouldn't be named out in the public and wouldn't be subject to anybody else threatening his safety either. Now, this was back in 2018. Well, he was sentenced in 2018, and he was sentenced to 7 years, which may on the face of it sound like a reasonable sentence, but given that you ordinarily serve half, as in it's a 7-year sentence and so you serve half of it in custody and the other half on licence, that is the typical thing. So actually he was released some 3 odd years later in 2021. When he was released in 2021, the Home Office said that he was a danger to the community and they issued a deportation order. They said, we don't want him in our country. We think he's a danger to the community because of the seriousness of this offence. And part of the tribunal said that they didn't accept his excuse that he didn't know that it was wrong, although he went on some kind of awareness training afterwards and then they were more convinced that he knew that it was wrong and so on, but ultimately was sceptical as to his argument that he didn't know that was wrong. But anyway, the Home Office issued a deportation order, but then this was appealed back and forth. As a brief aside, and as part of my regular warning to you to avoid scams and fraud, I have a bit of a story for you. One day, one of our clients came to us who'd had a bank account opened in her name along with several mobile phone accounts because a fraudulent actor had just enough of her information to convince these companies that they were our client. Identity theft plain as day. Now, whilst we were able to sort it out through the various mechanisms with these companies, it wasn't before it had a massive dent on her credit rating and a huge amount of stress and a long amount of time sorting all of this out. This was made possible because this fraudulent actor had just enough information. Now, I work with a company called Incogni on this channel who helps to prevent your information getting out there into the hands of these people that will try to convince these companies that they are you. Incogni is a service that will contact data brokers and marketers that gather together and sell on your data to other parties, and ultimately it might end up in the wrong hands, doing exactly what they did to our client. And Incogni will insist under UK and US law that they remove your data from their servers, thus preventing, hopefully, this from happening in the future. These companies gather together your information and they sell you as a product, because very often if you are not paying for something, then you are the product that's being sold. And so often when they say we might share your information with other parties, that's exactly what they're doing. They are sharing it on, and ultimately down the chain it gets sold on as a package. But Incogni is a done-for-you service. You sign up, you get a dashboard, and it will feed back to you the hundreds of companies that remove your data from their servers. One of our clients even ended up on the CFAS database. That's the fraud database, where she then could no longer get any form of credit, any form of account, anything whatsoever. She literally thereafter had to rely on friends and family, even for her mobile phone contract and paying for her bills, because she was the subject of identity theft. Of course, as a partner to my channel, I can offer you a fantastic discount. I wouldn't work with them otherwise unless I trusted them, and I got you a massive discount. So I get you 60% off with the code BlackBelt, which is in the description below, along with the link, and you get a 30-day money-back guarantee if you change your mind. But the peace of mind you get when you see just how many companies are removing your data from their servers, it will be staggering, and you'll be very pleased that you sign up. I certainly was, because I was surprised, even as a lawyer, just how many companies that I'd never heard of had my data. So sign up with Incogni, don't forget the discount code BlackBelt and the link in the description below, and you will be very grateful that you did so. But anyway, the Home Office issued a deportation order. First of all, he had successfully appealed to the Tribunal, and then the Home Office was fighting the corner to try to appeal that decision to uphold the deportation order, but the Home Office ultimately lost at the upper tier Tribunal, and that's this decision here. The anonymity remains, so I must warn you at this stage not to go hunting for identities and things like that, and certainly if you find them, not to make them public, because there's an anonymity order here for him to remain anonymous because of the risk of safety on his life. Now, again, as I said, the Daily Mail article is reasonably accurate here in that it refers to relative points of the Tribunal decision, which I'll now move back to. At one point, he had told the Tribunal that he was attacked with a metal bar, a machete and dogs, and that another man that he was dating was killed for being gay. Now, I would hope that we can all agree that those things are wrong and those risks to human lives are wrong, and thus that's the human rights argument to all of this. If someone is in this country and we uphold those human rights, which are given effect in ECHR, they're given effect by our Human Rights Act, we should as a community fight to uphold those human rights. But as the Tribunal quite rightly pointed out, this was a very, very finely balanced decision, the bit in red. It might not be big enough for you to read, but the bit in red here. The judge in the original Tribunal said, having considered the evidence relating to the issue as a whole, the original judge considered to be a very finely balanced decision, as in whether or not to allow that appeal and whether or not he should be deported. But it said, however, the judge was satisfied that there was significant evidence of positive rehabilitation, and for this reason she concluded that the appellant had rebutted the presumption that he constituted a danger to the community. So the judge accepted that because of some rehabilitation, which was evidenced. Now, judges will always look at the evidence, and I'll come back to judges in just a moment with a brief comment there, but had looked at all the evidence and said, well, that rebutted this presumption that it was a danger to the community. The presumption being that he had been convicted of a very serious offence, thus was a danger to the community, thus argued by the Home Office. But the judge looked at all the evidence and everything else that suggested that he'd complied with rehabilitation requirements and thus no longer posed a danger to the community. The judge then went on to consider whether the evidence showed that he had a well-founded fear of persecution, not prosecution, persecution, as in being attacked by the community at large for reasons of his membership of a particular social group, in other words, being identifying as bisexual. The judge accepted on the low standard of proof that he was likely to be as such, and took into account, this is a very interesting bit here, hence the different colours highlights, but took into account the Home Office's submission that there was only evidence to show that he'd ever been in a relationship with women since he came to the UK. Now, that to me makes it a little bit odd, because He was arguing that he was bisexual, but the Home Office said, well, there's only ever any evidence that he was having a relationship with women. And obviously this really awful offence was in relation to a woman. So I find it a bit odd that the weight of evidence there, of course I'm not the judge and I'm not criticising the judge because I wasn't there and I didn't hear the full evidence, but on the face of it I can see why that made it a very difficult decision. But the judge said that she was satisfied that he'd been in what he considered to be a relationship with an older man, but when he was 12 or 13 years old, which the judge considered to be abuse. But she accepted the evidence of the past because it was sufficiently detailed and consistent across multiple accounts, plausible in the circumstances during his childhood. He'd also been consistent about his orientation at with various professionals across interviews and statements and oral evidence, etc. But being somewhat cynical, does this not mean that if someone is just consistent with let's say perhaps he wasn't telling the truth, I'm not saying that he wasn't, but hypothetically, let's say somebody in his position was not telling the truth. That is to say, if someone is consistent all the way through, because being consistent is really one of the best ways a court will determine whether you're telling the truth or not. If someone is lying yet consistent all the way through, they might be able to hoodwink someone into believing that this is their true identity, and thus, if we have decisions like this, then surely being cynical, people in the future that are guilty or found guilty of these offences might then have all along this idea that they're going to feed in this story and evidence across interviews and statements and oral evidence, that they have some characteristic that would mean they'll be persecuted if they are deported and sent back. Thus, the ultimate decision is likely that they won't be sent back if they are convincing enough through all of that evidence. And I come to that view, the cynical view, because of the fact that the Home Office argued that there was only evidence to show that he'd ever been in a relationship with women since coming to the UK. Nonetheless, the tribunal accepted his arguments there. This appeal, this upper tier tribunal, was the Home Office fighting against that decision, who actually wanted to go on to deport this man. The judge in the original decision went on to look at the country guidance, etc. Men who are perceived to be homosexual and for this reason have suffered persecution in Jamaica are likely to be at risk of persecution on return. But ultimately, the Home Office argued on multiple grounds. Firstly, that the first tier tribunal failed to give adequate reasons for the finding that he'd rebutted the presumption that he was a danger to the community. And secondly, that the first tier tribunal failed to give adequate reasons for finding that he was bisexual and therefore member of that group. But ultimately, in the decision, the upper tier tribunal said that the original judge was entitled to take into account the evidence, and the first ground, as it was drafted, was no more than a disagreement with the judge's findings, and that ultimately there was a balanced view on a balanced decision, and the judge was entitled to come to that conclusion. So on the one hand, you might argue that it's the correct decision in that he might be persecuted and his life at risk if he was deported. On the other hand, if you're of the more cynical persuasion, you might believe that actually the laws, the human rights laws, are preventing the Home Office from fighting for the safety of the rest of the community by upholding its decisions to deport what it calls people of a danger to the community, because they make arguments and provide consistent evidence throughout that they might be persecuted if they are deported and returned to their country of origin. So ultimately what that means is somebody can commit a really serious offence and then claim to be part of a group that they'll be persecuted upon return to their home country, and thus we are unable to deport them. This is a very dangerous precedent to set, even if it's the correct one from a human rights standpoint. It is still a very dangerous precedent to set for the country in that we cannot deport what may still be dangerous criminals, even though a tribunal has accepted that there was evidence of rehabilitation, etc. If you're of the cynical persuasion, you may believe that actually he might have been just playing along and actually still constitutes a danger to the country. Because, after all, people can and very often do reoffend, even with very, very serious offences. And so, ultimately, we may end up with lots of people here whom we are unable to deport because of human rights laws. Now, I said I'd come back to judges for a brief moment as well. None of this is to criticise the judges, because what they do is look at the evidence before them. There's been a lot of criticisms of various decisions of late whereby the judge has made a ruling that lots of people disagree with. But I must stress that the judges look at the evidence presented to them. If we take an extreme case whereby a defendant to a case makes a bold statement about what their defence is, but provides absolutely no evidence whatsoever to back it up. Now, the defence itself, let's say it's a civil case, the defence would be a defence, that's their statement of case. In a civil case, it's their defence statement, so it is a broad outline of what their defence is. But then if there is no evidence whatsoever to back that up, it's very difficult then to believe that. Now, in a criminal trial, it differs from civil in that in a criminal trial, the prosecutor must still prove the case against the defendant, whereas in a civil trial, if you don't deal with an allegation, you're deemed to accept it, and if you make a bold statement as to what your defence is but provide absolutely no evidence whatsoever, then it's difficult for a court to rule that your defence is accurate. Now, given this situation, and any situation like it, the judge is only going to look at the evidence presented and weigh up that evidence accordingly. So sometimes cases fall down because the evidence is not presented properly, and sometimes the evidence just is what it is. It shows on the face of it that something has happened, for example, the rehabilitation here, and the judge just really rules on what is in front of them, and they can't really go outside of what's presented in court. So on the one hand, whilst you might see headlines like this and they might lean left or right, and you may see a bold headline which may be cherry-picking certain parts of it, actually the blunt statements of it are inherently true. There is always a bit more to it, which is why I like to read the tribunal decisions, which are freely available, although in this case, as I say, there's an anonymity order made, so you must be careful as to not research the identity of the people involved and certainly not make those known publicly. But as for these decisions, it is a public justice system, so most of these are publicly available, even if not reported, sort of formally reported in law reports and so on. But I hope you found that interesting. Some of you obviously may be upset that the Home Office is struggling to fight for the protection of our community. They are in some sense hindered by the laws that inherently protect people that have committed crimes against our own country. But either way, I hope you found that interesting and a more deeper explanation of what would otherwise be a simple headline. Please do like the video and subscribe down below. As I say, I depend on you. I am so grateful for 700,000 subscribers. Let's get to 1 million with your help, and I will keep helping you to understand law. Thanks for watching.